Tom, welcome to Constituting America's Constitutional Chats. We're going to ask you to say a few words about our topic today, which is landmark cases of the Supreme Court, and continues our, I think, 12-week now series on checks and balances, and then we'll go to questions.
Well, thanks for having me back. When we talk about landmark cases, I'll just start with an observation about what a case is, and then what makes it a landmark case. Article 3 of the Constitution gives the power to decide cases and controversies to the courts. Those are specific legal disputes answering a legal question. What makes a case landmark, that probably means many different things to different people. Sometimes it's just a famous case. Sometimes it's a case of first impression. That's what lawyers refer to as when a court addresses an issue for the first time. Sometimes it's a case that has a big impact on a significant part of the population, or interpretations of foundational principles. And sometimes it's just a terribly wrong decision that everyone comes to agree shouldn't have been made in the first place. So it can mean any or all of those things. I think of it in terms of a decision by the Supreme Court on an important constitutional issue. Especially those that kind of plow new ground. They're an interpretation for the first time of a constitutional provision, or perhaps the first time establishing or explaining a fundamental principle. So I'll give you a few examples that I think fit any or all of those criteria. The first that I'm sure people have heard of is Marbury versus Madison, decided in 1803. That was a case where John Adams had lost the 1800 presidential election, and just before he went out of office, at that time, Inauguration Day was on March 4th, he made a whole bunch of judicial appointments, and the Secretary of State, James Madison, didn't get around to actually delivering the written commission to everybody, including William Marbury. Madison, once Adams was out of office, Madison refused to deliver that commission, and Marbury sued. The Supreme Court, Chief Justice John Marshall wrote the opinion. They said that while William Marbury did have a right to that commission, the statute Congress had passed authorizing the president to make those appointments was unconstitutional. So it was the first time that the Supreme Court had actually said that a statute was inconsistent with the Constitution, and therefore it was void. So that's why people say that it started the principle, or established the principle, of judicial review. A second landmark case would be Dred Scott versus Sanford in 1857. This case is notorious for a bad reason. Dred Scott's owners, they had lived in Missouri, which allowed slavery. They took him to Illinois and Wisconsin, where slavery was illegal, then back to Missouri, and Dred Scott claimed that he therefore was a free man. Chief Justice Roger Taney wrote the decision in Dred Scott versus Sanford, disagreeing with Dred Scott, saying that the Constitution did not permit blacks to be citizens. And this is kind of a notorious case of where the politics of the justices really had more to do with the outcome than the Constitution did. A third landmark case, which maybe people haven't heard of, is called Gitlow versus New York. This is in 1925. It was the first case of what's called incorporation. That is, the 14th Amendment has a due process clause, and beginning with Gitlow in 1925, which had to do with the free exercise of religion, the Supreme Court held that the provisions of the Bill of Rights, Amendments 1 through 9, which say Congress, also apply to the states. And the Supreme Court has incorporated kind of provision by provision the different parts of the Bill of Rights and applied those to the states. And the most recent was in 2010 in a case called McDonald versus City of Chicago, where the Supreme Court incorporated the Second Amendment right to keep and bear arms so that states, as well as the federal government, were bound by those restrictions. Another landmark case involving the establishment of religion, also in the First Amendment, was called Everson versus Board of Education in 1947. This incorporated the Establishment Clause. It prohibited states as well as the federal government from establishing a religion, but it also introduced the phrase wall of separation between church and state into our understanding of the Establishment Clause. There's not a good case to be made that that's how the Establishment Clause should be interpreted, because that phrase came from Thomas Jefferson years after the First Amendment was ratified, but it stuck with the Supreme Court for quite a while. They've changed the way to understand that Establishment Clause a few times since then, but that was the beginning of it. And then an infamous landmark case, Roe versus Wade, 1973. The Supreme Court said that the 14th Amendment protects a right to abortion. That is not in the text of the 14th Amendment. So that by itself was controversial, even apart from the subject matter. And it was a criticized decision. It was never really settled among legal scholars, even those on the left or the right of the political spectrum. And the Supreme Court overruled the Roe versus Wade decision 3 years ago in a case called Dobbs versus Jackson Women's Health Organization. Another landmark decision was in 1992 was called Employment Division versus Smith. This had to do with the First Amendment's protection for the exercise of religion. Traditionally, the Supreme Court had very vigorously protected that right. And they said that it would be very difficult for government to undermine the exercise of religion. In the Smith case, the Supreme Court kind of did an about face and said that rigorous protection only applies in a very narrow category of cases, and the government actually had a lot more room to undermine the exercise of religion. That prompted Congress to try to respond with legislation. The Supreme Court then struck that legislation down. But that was a landmark decision, both for how it interpreted the First Amendment, but also the fact that the Supreme Court did that change on its own. The parties hadn't asked it to do that. And then the last one I'll mention is called Loper Bright versus Raimondo. You may well have never heard of that one either. This was just last year. As people know, government agencies in the executive branch of the government, they issue a lot of regulations and a lot of rules. And when those rules get challenged, sometimes the argument is that, well, the statute that Congress passed did not allow the agency to produce the regulations that it did. And for a long time, the courts were very patient and very deferential to agencies to say whether they had the authority from Congress to do what they were doing. That kind of abdicates the authority to decide that from the courts to the agency. And that's always been a little bit controversial. Well, the Supreme Court corrected that last year and said, no, the courts have to decide. Does Congress authorize agencies to make rules? Are those rules consistent with what Congress has passed? And it put the authority really over those regulations back into the judiciary's hands, where it probably belongs. So these are some landmark decisions that sometimes provided the first interpretation of a constitutional provision or the establishment of a basic principle that government operates on. And of course, everybody's got a list, and most of them are a lot longer than that. But those are the ones that I've chosen for us to discuss today.
Well, thank you, Tom. And I know when we talked about this topic, you said, you want me to cover all of the landmark Supreme Court decisions in 8 minutes?
I almost did it.
Yeah, no, I think you did a great job. Thank you so much. And we're going to put in the Q&A link, in the Q&A trail, I guess, a link that Tom and I talked about, the Constitution of America a few years ago actually did an online study on our Supreme Court cases, landmark Supreme Court cases. And we've got essays from constitutional scholars all across the country on, I think, about 90 or so landmark Supreme Court cases, as well as essays on some of the more famous justices. So we'll be sure and put that in. And we're going to go to Jewel for questions. But Tom, I think you also wanted to mention that the Heritage Foundation is coming out with a interactive constitution here in the next few days in time for Constitution Day, and
Oh, yes.
reference some of the. Do you want to mention that real fast before
Thank
we
you
go
for
to
that. It's
Jewel?
called the Heritage Guide to the Constitution. This will be the third edition. The first was in 2005, the second 10 years after that, and this is 10 years again since the last one. Completely revised. The thing that makes it really useful is that there's a separate essay for every clause of the Constitution, 216 in total. And they're all from an originalist perspective. That is, what did the framers of the Constitution seek to do in each of those clauses? We have over 150 legal scholars, constitutional law experts, and even 30 sitting federal judges who contributed these essays. Justice Samuel Alito from the Supreme Court wrote the foreword. So it really is a tremendous resource. It'll be officially released at an event here at the Heritage Foundation on September 17, which is Constitution Day. But heritage.org/constitution is where you can find it online. It's really user friendly, surprisingly. And I hope that that will really help people to understand further our great Constitution.
Great. Thank you so much. And like I said, we'll put a link in to our online study in the Supreme Court as well on the Q&A. Jewel, do you want to lead us off?
Sure. This is Jewel Gilbert, Constituting America. Hello. What a rush of information with the landmark cases. So, as I am not a legal scholar, and many of our listeners are not, and students, of course, wouldn't be at that level yet. And also, a lot of this history is things that some of them I'm hearing for the first time. So, could you maybe tell me? We did multiple shows on the Supreme Court and its power, and we did a show about the Supreme Court and understanding maybe judicial supremacy versus other ways of seeing the Supreme Court's power. Of the cases you listed, and maybe any that are missing from that, are there still great outstanding contradictions that need to be resolved? Do you think that some of the recent, or do you think that most of those contradictions in these recent rulings we've seen have that the court has taken most of those on already?
Well, I think in my view, the proper way to understand, to interpret and apply the Constitution, to me, that the word impartial comes to mind. But impartial interpretation, when you interpret something that someone else wrote, you're trying to figure out what they meant. And so in doing that impartially means, not putting your own opinion into the mix, but genuinely trying to find out, what did that person mean by what they wrote? And that's how the Constitution should be interpreted. It hasn't been interpreted that way for different parts of our history. I think the founders of the country were clear that it should be, but there have been many departures from that. I gave a few examples of that. Those interpretations, even though I think they're misguided, they stay in operation until the Supreme Court chooses to abandon them officially, which in the case of Roe versus Wade, they did. I mentioned that. Otherwise, we do have on the book, so to speak, interpretations of the Constitution that are more the product of the Supreme Court's opinion and kind of their personal views than they are an objective reading of the Constitution. And sometimes these different things do contradict each other. They're very difficult to reconcile. And there's a lot of those, difficult situations that confront lawyers as we try to argue certain positions and this type of thing. So there's a lot of that out there. It hasn't always been done right over the years. Sometimes the Supreme Court will correct its errors and try to sort out some of the confusion. But until there's a really compelling reason for them to do so, we got to live sometimes with the product of the justices that our leaders have appointed.
In the landmark cases that you listed, do you think that any of those cases particularly require another ruling, like as in that, because of the way that one of those landmark cases was ruled on, that it's just needs to require another ruling for clarification, or because of situations that are going to arise from that ruling?
Well, I mentioned the Employment Division versus Smith decision. The First Amendment protects the right to exercise religion. And the courts were very consistent for a very long time that since this was what's called an inalienable right, that's the highest, most significant category of rights that we have, that the government, it's always should be difficult for the government to undermine that right. Up until Employment Division versus Smith, the parties in that case did not ask the Supreme Court to change that. They didn't brief that issue. They didn't argue that issue. The Supreme Court, just on its own, practically turned the free exercise clause of the Constitution on its head. And I think that really needs to be overruled. It needs to be, it's completely inconsistent with an original understanding of the free exercise clause. It was completely unnecessary for the Supreme Court to do that, to decide that case. And I really hope that a case comes to the Supreme Court that raises that issue in a way that allows the court to return to its more faithful and impartial interpretation, so that that right that we all have can be fully protected. So I of the ones that I mentioned, I would really highlight that one as really needing to be overruled, and for the Supreme Court to correct a really misguided interpretation.
Interesting. Do you think that the modern Supreme Court justices and um that the American politic and the modern justices themselves, that they have the same view of the power of the Supreme Court, or uh are we still at, like, is that still an open argument, or are we still trying to decide among people like yourself, among these justices, that they are also at odds about what the power of the Supreme Court is or should be? Or is that settled, or do we have like consensus right now?
Well, at a very, very general level, there's consensus in the sense that the judiciary is one of three co-equal branches. There's very general agreement on the role of the courts generally, and the Supreme Court in terms of addressing legal issues and settling legal disputes. But the more narrowly and specifically you get, that's where some of the divisions come in as to how to do that. Um, on this court, I think there's at least 5 justices, maybe 6, depending on the case, who have a general perspective that the court has a limited category of power, that they have to respect what the Constitution says and what it was intended to mean, that they do not have the power to change the meaning of the Constitution. I think there's 3 justices who believe they can, who believe in a much more robust, powerful judiciary. That varies over time. Of course, as I'm sure you know, the president nominates and the Senate has to approve appointments to the Supreme Court. They serve what the Constitution says during good behavior, meaning until they choose to leave. They don't have specific terms. So sometimes there's a big gap between appointments, sometimes there's a short one. But I do think it's very important, the kind of justice that presidents appoint. The more powerful the courts are, the more power they have over the Constitution, which means the more power they have over what our rights are. I don't want to be governed by the Supreme Court. I want to be governed by the Constitution, and those are not the same thing. So it's always going to be an issue about how powerful the judicial branch is and is supposed to be. And that's why these kinds of discussions, I think, are very, very important. We shouldn't just leave that to the lawyers or to the law professors or to the judges. I think the American people, it's their government, and this is part of it, and they need to understand it and really get clear how that portion of their government is supposed to work.
As far as exerting political power for the Supreme Court, when we have let's say let's say the cases that involve the Commerce Clause, or a case that involves praying in schools, or a case that involves we recently had done we had done a show about, there was a case about a really important case that had come up about corporations and the government. I can't remember what it is right now. In these cases, do you think that when there is a landmark case that it is good or bad, um, regardless of do you think that if when the Supreme Court makes a ruling that has wide sweeping implications, that if it improves the country, if it gets us closer to, I shouldn't say that, I should say if it gets us closer to a correct interpretation of the Constitution, that's always good. And if it gets us further from that, then it's always bad, regardless of the whether or not it seems as if the judicial branch is legislating. I know that's a loaded question, but
No, I think it's good. Our liberty requires limited government. We need government for order, but we need limits on government in order to preserve our liberty. And that requires that government in all of its branches operate under the terms and the rules that the people establish in the Constitution. That includes the judiciary. The judiciary is not there to do what they think is a good thing. They're not there to do what I like. They're not there to do what some politician thinks is a good thing. They're there to follow the supreme law of the land, which the people own and determine what it says and what it means. So anytime that a branch of government acts without legal authority, that is, they act outside of the power that the Constitution gives them, our liberty is threatened. So I think the courts, as well as the legislature and executive, have to stay within their designed role. That's why we have to understand what that role is in order for our liberty to really thrive.
all right, thank you very much. Those are fantastic answers, and I'll pass it now.
Great. Jewel, I think we're going to go to Janine next.
Great. Hi. Thank you. It's Janine Turner here, founder of Constitute America, which we, I guess, established in the opening. How you doing? Thank you so much for this discussion. It's so broad, and I'm trying to kind of wrap my brain around it. We discussed a lot of this last week, but I guess one of my questions is, are twofold. A, what defines a landmark case, really, in your mind? But B, Jewel was touching upon something, and this is always the big discussion. You have the Supreme Court justices, which by precedent are supposed to um, interpret the cases that come to them with based off the Constitution. But there's a dilemma when there is which we touched on today as well, when there is a vastly different interpretation of what the Constitution is saying. Whether you're you believe the Constitution, what it says is what it says, or if, in other words, there are judges that say the Constitution, we're going to go by the word and by what it says, and there are other judges, or justices, I should say, on the Supreme Court that say, well, I'm going to kind of go with how society's moving. And it's really more important to me what society thinks and what society today wants. And I'm going to interpret the Constitution in any way I want to skew it to be what society wants. It seems to me it would be, why is that's a bit of an issue, is it not? With all these landmark decisions and the power that the court has, though it can be overruled and overturned by amendments and new laws and things of that nature. But it
Well,
just seems that there's a conflict within our Supreme Court about how to interpret the Constitution, which means that the laws are going to be interpreted very, very differently.
Well, the debate about how much power the court should have began when the Constitution and our system of government was established. Marbury versus Madison.
Yes, but may I stop you right there?
Landmark
Hang on one second. That's not exactly my question, though. My question
I was
is,
getting to the answer to your question.
okay, thank
Marbury
you.
versus Madison, which I mentioned in the landmark list, said that the reason we have a written constitution is so that the rules it sets for government will be neither mistaken nor forgotten. There is no doubt that the framers and founders of our system of government thought that the Constitution should be interpreted based on what it originally meant. So that judges that depart from that and try to give it a different kind of meaning, you referred to, kind of what society thinks. Objectively speaking, judges have no authority to interpret the Constitution based on what society thinks. What society thinks is not the law, the Constitution is. So there are some objective standards for evaluating how judges go about deciding cases. What's their approach to interpreting our written Constitution? And again, that's why programs like Constituting America and all the different things that you're doing are so helpful to help our citizens understand this. But not everybody does it that way. There have been many justices appointed who believed they had power over the Constitution, that they were not subject to the Constitution. I think that's fundamentally wrong, and objectively so. But that's happened. So we do have a lot of precedents that have been on the books, including, I mentioned, Roe versus Wade, bad precedents that misinterpreted the Constitution, and sometimes we have to live with those. The Supreme Court, isn't always completely free just to decide every day, what precedent am I going to overrule today? They have to go through a judicial process before they can do that sort of thing. But again, that's why it's so important, the kind of judges and justices that a president appoints. Do they think that they, not the Constitution, are the supreme law of the land? And so, yes, we do have different kinds of precedents. Sometimes they conflict, but there is a right way, a design for our system of government that requires judges to treat the Constitution not as their own creation, but as the people's instruction about how the government is supposed to operate.
Yes. Well, thank you for that answer. I guess, as our founders said in the Federalist, men are not angels. So, meaning that men and women are human, and we're all apt to make mistakes. Um, but since they believe that, they created a checks and balances within our Constitution that checked the power for when someone interpreted wherever they are in whatever branch in a wrong way. There could be a check on that. What I think a lot of Americans are finding frightening, it's unfortunate, really, that if you're going to be a justice on the Supreme Court, that everybody just doesn't come into it with the same interpretation, which is, we're going to stick to the letter of the law here, and we're going to interpret everything based off the Constitution and not be swayed by popular polls. But that's not what happens, as you stated. There have been cases that have been misinterpreted, or they weren't really abiding by the Constitution in the first place. And I just think it's a shame that if someone's going to be whether you're Democrat, Republican, Independent, whatever you are, if you're going to be a justice, it just needs to be sort of a requirement, should it not? Like a check on the Supreme Court, that if you're going to be on the court, you have to interpret it based off the letter of the law of the Constitution. However, I guess what my final question on this subject would be is, I think we have a really good set of checks and balances, very thorough in the legislative branch. I think we have really good checks and balances in the executive branch to make sure that they don't get too powerful. I don't think we have very good checks on the Supreme Court. And everybody thinks that they're the be all and end all, and that's the end. But of course, we can do an amendment to overturn it, which they did with really Dred Scott. I guess that someone could ignore it. The president could ignore it. The legislative branch could write a new law to combat it. But there doesn't seem to. But that all takes a lot of work. I don't think there are really good checks on the Supreme Court. What are your thoughts about that?
The ultimate check is the one I mentioned just a minute ago, and that is appointing the right justices in the first place. The main issue, not their legal resume or their legal experience. Let's assume any nominee to the Supreme Court is going to be a smart lawyer. The issue is what they understand their role, their job description to be. If that job description is not consistent with the way the founders of our country designed the judiciary, and it's not difficult to know what that design is, if their understanding of what their job's going to be is not consistent with that, then they don't belong on the Supreme Court.
But the thing is,
Senator Orrin had
sometimes
from
sorry to interrupt, but I only have 2 minutes left. But the thing is, they may be Thomas. They may not belong on the court, but they get on the court anyway. Just like you might elect a president that's maybe wasn't a good president, or a legislator or a senator that's not a good legislator or senator.
checks and balances
And
don't always work. That's true.
if there is a president that's not abiding, or a senator that's not abiding, there are great checks on those people. If someone gets into the Supreme Court that is not abiding by the law, and they're there already, it maybe, I understand what you're saying, it's they shouldn't belong there in the first place, but they're there for life. So if they're there already, what do you consider to be the best check if they're not abiding correctly?
If the only way to remove a federal judge is by impeachment. That's for high crimes and misdemeanors. The Constitution spells out what that standard is. A judge's decisions really don't fall into that category. Frankly, our system does have a lot of checks and balances, at least on paper, and sometimes they don't work. The American people choose their leaders, and their leaders don't always do the right thing. Sometimes we simply have to live with the results of the political choices that we make. Not everything that every branch of government does wrong can be checked and corrected. Frankly, we are living under many different misinterpretations of the Constitution from the Supreme Court, and that's because the leaders we've chosen have picked judges who think they have too much power. So ultimately, you got to pick the right judges in the first place. And if the judges do what they're not supposed to do, if they don't stick to what their job description is supposed to be, we got to live with it, to be honest. The next election, we ought to maybe make doubly sure that the person we elect as president is more committed to finding the right kind of judges in the first place. But sometimes we have to live with our mistakes.
Well, we don't make any comments about presidents here. We stay non-political, nonpartisan.
Nor do I.
But I think that I would like personally to see better checks on the Supreme Court. I think that would
I'm
be.
not sure what those checks would be.
Okay, well, I'm going to pass now. Thank you, Thomas. I'm going to pass to my comrade here.
I'll just finish on that briefly on that one idea. I'm not sure what those checks would be without really trying to manipulate how the courts decide their cases. The independence of our courts from politics is also very, very important. So checks only go so far before you start really interfering with a judicial branch that's supposed to be independent.
Well, thank you, Tom and Janine and Jewel and Kenyon. We're going to go to you next.
Thank you, Kathy, and thank you, Mr. Thomas, for being on today. The first question I'll ask is maybe like piggybacking off what Janine was saying, is that as being like a justice, you kind of have to like follow what the Constitution says. But I was going to say, if you're going to try to, maybe let's say as a check on the Supreme Court, you want to put what they have to decide, like based on what the Constitution says. Like the problem would be who like decides exactly what the Constitution says other than the court. So like my question would be, how would that exactly work, really?
Well, the answer to that question, we can all read what the Constitution says. The real issue is what the Constitution means. You know, like I said, if you see a sign or you take a test from your teacher, you can read what the test says, but if you're not really clear about it, you got to make sure that what did the teacher mean by the question that's on your test? And so we do that all the time. We try to figure out what someone else meant by what they either said or wrote. Do the same thing with the Constitution. We know who gave us the words of the Constitution, and we got to go to them to determine what they meant by those words. We start with what the words just plainly mean. We refer to the plain meaning or the accepted general meaning of what the Constitution says. But if that doesn't give us, though, the answer, the complete answer, we still have to figure out what did they mean by what they wrote. That really narrows down the amount of discretion that judges have. Judges can't just make something up. They can't just say, well, I think it means X, Y, or Z. They gotta focus on that narrow question about what the framers of the Constitution meant. Judges don't always agree on that, but it's much more reliable than if we let judges just make it up as they go along. So understanding what that job is for judges, what they're supposed, what's their job, what does it mean to interpret something someone else wrote, and stay focused on that. And you got to know going in that a judge says, that's my job. I can't make it up. I can't substitute my opinion. I have to stay focused on trying to determine what the Constitution was intended to mean. So staying focused on the right issue really helps to stay, to keep narrow. Mistakes can still be made, but they're going to be a lot fewer.
That makes a lot of sense. Thank you. I was gonna ask about, there was a case I heard about called like McCullough versus Maryland that was kind of instituted implied powers of the of Congress from what I read about it. Could you kind of explain what happened in that case, and would the founders agree with the ruling there, or was it like a more of a misinterpretation?
Well, we do have a written Constitution, and so the Constitution enumerates or it lists the powers of government. That's in Article 1, and there's specific powers that are listed. And the founders did that to try to make clear these are the powers government has, and if it's not on the list, then the government doesn't have those powers. Still, a lot of those powers was mentioned before, the power to regulate commerce, for example. They seem fairly general. You got to fill in the gaps, and Congress might have to do a bunch of things in order to implement that power. And so that's why we have what's called the necessary and proper clause of the Constitution. Article 1 lists those powers, but then it also says, and Congress has the power to do whatever is necessary and proper to carry those powers into exercise, to actually implement those powers. You can call those implied powers. The Constitution would probably be 1,000 pages long if you had to list every single little minute detail, and constitutions don't do that. So the founders of our country struck a balance between a written Constitution that spells a lot of things out, and then a little kind of some flexibility there with regard to implied powers. I think that's the way the founders designed it to be. Obviously, that second category, the implied powers, that can't be just anything, or it would, sort of neutralize the whole purpose of listing what the powers of government are in the first place. But I think that's the way they designed it. They want government to work. It's just that they wanted the description of what government powers are to be more clear and defined so that they wouldn't get out of control. I hope that addresses the question.
That does address it very well. Thank you. It makes sense that you can't just, you have to have some implied powers, otherwise it would be way too complex.
And otherwise, it just won't work. There has to be some discretion, but you give government a little bit of discretion, and it's going to be running 10 miles ahead of you. So you gotta have some reins on there without it being too tight that government can't do anything that you want it to do.
Very true. Thank you for answering my questions. Now I'll toss to Kathy because I'm sure we have a lot of audience questions.
Thank you. Great questions.
Thank you, Kenyon and Tom, and it's been a great discussion so far. We do have a lot of audience questions. And first, we want to give a shout out to some of the teachers and schools and students watching today. We have John Studer from the Haverford School with 66 students. We have D'Angela Hines from the Emerald Coast Christian Academy with 8 students. And Paul and Peggy Forster are both emeritus teachers of mathematics. So if you are a teacher or a student watching and you want to get a shout out, let us know in the Q&A and we'll be sure and recognize you before the end of the program. We also want to thank our listeners at Las Vegas's KKVV 1060 AM on the radio dial. KKVV airs Constituting America's Constitutional Chats on Thursdays at 6 p.m. Pacific. So thank you to everyone in Las Vegas who's listening. I think we're going to start with our board member, Jay McConville, who is on today. And hi, Jay. And Jay first gives a shout out to our sponsors. He says, thank you, Jane and Greg Gandy, for all you do for Constituting America. And I echo that. And then Jay also has a question. One of Jay's favorite cases, he says, my favorite, I'm sorry if you mentioned it and I missed it, is Wickard versus Filburn. I understand that it has recently been trimmed back, tightening the rules regarding using the Commerce Clause as a justification for expanding federal power. What are your thoughts on that?
That's a great question. The Constitution lists among the powers of Congress the power to regulate commerce among the several states. We all know what commerce is. It's economic transactions. We know what among the several states means. That's what the Constitution says, and its meaning is clear. The only question was whether, we're going to obey it. And of course, the Depression came along. Wickard was decided in the late 30s, and people wanted the federal government to have a lot more power than the Constitution was designed to give it. And so Franklin Roosevelt, he appointed justices who had a very different view. They felt that they could interpret the Constitution based on what they thought the country needed. So they interpreted the Commerce Clause not to regulate commerce, but to regulate anything that affects commerce. You see the big difference between those two. And Wickard versus Filburn was a challenge to a law that limited how much wheat a farmer could grow on his own land. And what the government wanted them to do was to buy wheat in the open marketplace rather than just grow and use your own. But the question was, is that commerce? Is growing your own wheat to make bread to eat at your own table, is that commerce? Well, no, it's not. And so that was a case of where the reinterpretation, departing from what the word commerce was supposed to mean, really expanded the power of the federal government. That has been, in the last decade or so, kind of edged back a little bit. It hasn't been changed really significantly, but you remember when the Affordable Care Act required people to buy insurance. The question there was whether the Commerce Clause allowed Congress to require that you buy a certain product. So those issues still come up, and it's been tightened up a little bit, but we still do have a pretty expansive, much more so than I think the framers of the Constitution intended, a really expansive reading of what federal power is.
Well, thank you. And then we have our audience has had a couple of ideas and questions on maybe ways to check the power of the Supreme Court. Demetrius Berlos asks, what about term limits as a possible check on the Supreme Court justices? What do you think about that, Tom? And have there been any movements throughout history that ever gained any traction on that?
Well, not traction per se. The idea has been proposed. I would say the idea of judges having unlimited terms, that's actually in the Declaration of Independence, believe it or not. Two of the reasons that we got independent from Britain was that the king had too much power over judges and whether they were on or off the bench, and he could retaliate when they did something wrong and this kind of thing. And the Constitution protected how long judges served for that reason. And I think it was a good idea. You know, if you have the wrong kind of judge, it doesn't matter whether you have three bad judges for 10 years or one bad judge for 30. If you got the wrong kind of judge exercising too much power, the length of time that he's there doesn't really matter. I don't think that the length of time is the problem. I think the kind of judge that we appoint is the problem, and that's really where our focus, I think, needs to be. You'd have to amend the Constitution anyway to term limit federal judges, and I don't think that would be practically possible.
Well, thank you. And then Professor James Klinger says Congress could limit the jurisdiction of the federal courts. In fact, it has limited court jurisdiction in certain kinds of cases, such as court challenges to the Alaska pipeline.
Congress does have the authority to regulate the appellate jurisdiction. The reason that that's not really a practical solution to problems is that it's prospective only. Almost always when we start talking about restricting jurisdiction, it's because a bad decision has already happened. And so restricting appellate jurisdiction to prevent cases or decisions like that in the future doesn't take that bad decision off the books. So it's not quite like two ships passing in the night, but that's not really a solution that directly addresses the problem. But Congress does have some authority there to regulate. Congress creates the lower courts. The Constitution created the Supreme Court. So I think there is a difference in how much Congress can do with regard to the lower courts versus the Supreme Court. So that there may be some reasons to do that. But I think in the typical situation where we talk about that as a possible reform, I don't think it would really address the problem that needs to be addressed.
Well, thank you on that. And then Judith got on late and was wondering what the first two cases you started with. I know you started with Marbury Madison. What was your second one?
Let me check my list here. It was Marbury versus Madison and Dred Scott.
Yeah, okay, that's what we thought. And I reminded Judith, and I put in the Q&A trail that we do repost our podcasts on all podcast platforms, Apple, Spotify, YouTube, and I gave a link on our website where you can find all of our past podcasts as well. And let's see, going back up here, Joe Buford, who I want to give a shout out to Joe. He's a great supporter of our Constituting America online auction, has donated items and bids on items all the time. So Joe, thanks for being on with us today. Joe says, can you discuss the effect and constitutionality of Reynolds versus Sims, 1964, that mandated that state senates be apportioned by population, the same as state House of Representatives? This seems to disenfranchise the rural areas of each state. Are you familiar with that one, Tom?
I am. In the states as well as at the federal level, oftentimes the House and the Senate are apportioned differently. That is, like, for example, in Congress, the House represents population, which tends then to give more of a voice to larger states, and the Senate represents states, which gives more of a voice to the smaller states. And the same thing occurs at the state level a lot of times. And that is intentional. It's to give, in the combination of those two ways of doing it, complete representation of the different kinds of constituencies that might exist. And in Reynolds, the Supreme Court essentially imposed their own rule, one person, one vote, as if a very different principle was supposed to govern state legislatures. That doesn't come from the Constitution. It came from the Supreme Court. Maybe they thought they had a better idea. But I think it's true that changing that system definitely has effects on who's represented more fully, and which it's the system together. It's the two houses in combination that serve especially a diverse state particularly well. And in Reynolds, that was one of a number of cases where they seemed to substitute a different system that they thought would be better. And I'm not sure that the Supreme Court really has authority to do that.
Well, thank you. And then Amy Winchester asked, isn't so much of interpretation now based on case law and not truly reassessing the Constitution and its original intent?
Well, I touched on that a little bit when I said precedent. That's another word for case law. That is the past decisions by the Supreme Court. It's not that, a decision disappears after the Supreme Court announces it. It stays on the books, and it has, we do want some consistency in the way that our courts operate. But a justice once said, I take an oath to support the Constitution, not what the Supreme Court has said about the Constitution. So, if precedents are inconsistent with the original meaning of the Supreme or of the Constitution, then those precedents are wrong. The Constitution's not wrong. It's not always possible to reverse wrong precedents. As I said before, sometimes we have to live with mistakes like that on the books. Sometimes, as in, certain cases, it is possible to correct those mistakes. But I do think it's important to get clear just what the supreme law of the land is. And that is the Constitution as we, the people, framed and ratified it. It's not the Constitution that the Supreme Court wants to be on the page. There's a big difference between the two. And understanding that difference really allows us to understand our system and to evaluate what the Supreme Court does better.
Well, thank you. And we have one of our very regular listeners, Sandy Thatcher, is very, very interested always in copyright law. And he really believes that every student in the country needs to know about copyright law because they're all affected by it. His question is, and I'm going back up to it. Okay, there was a 1994 SCOTUS decision that decided the landmark copyright case of Campbell versus Acuff Rose Music, finding in favor of the rap group Two Live Crew that its parody of the song Pretty Woman was fair use, employing the concept of transformative use that had been first introduced by Judge Pierre Lavelle in a Harvard Law Review article in 1990 titled Toward a Theory of Fair Use. Let's see, Sandy's basically saying this is one of more than 30 lawsuits now underway in the courts across the country where copyright owners have sued AI companies for using copyrighted material in their training of chatbots. At the core of all these cases is the idea of transformative use. How do you think this case might come out when SCOTUS gets it on appeal in light of the 1994 decision?
That is a very that area of the law is very much in flux. There was a case just a couple of years ago involving Andy Warhol's art. He would reproduce an image, but kind of in his own sort of color style. The question is, well, who holds the copyright of that image? Is it his kind of transformed image, or is it the original image? AI is going to present just a host of challenges. Because if artificial intelligence actually creates something, who holds the copyright to it? If AI helps someone else create something, I mean, there's just unbelievable. It doesn't take much imagination to understand there's going to be all sorts of problems. The real issue is who created a work. They are the ones that are supposed to hold the copyright or a patent, in the case of an invention, to that work. And that used to be pretty easy to figure out. It's going to be much more difficult in the future. The Constitution does recognize the importance of holding copyright in your own creations. That is a property right that you have. But it's good. But those lines are getting blurred as we develop technology.
Well, thank you. We are right at the top of the hour, and we want to thank you so much for being with us today. It was a fascinating discussion as we continued our look at checks and balances and in the judicial branch. And so We thank you for being with us, and we thank our audience for your fantastic questions. We're sorry we couldn't get to them all, but we invite everybody to join us next week, Tuesday at 2 Eastern. We'll see you here.
Thanks, Kathy.
Thank y'all.
Hey, guys.
Bye.